Hello, my name's David Runciman, and this is Past, Present, Future, the History of Ideas podcast. Today, we are returning for a final set of episodes in our series, Politics on Trial. We've reached the later part of the 20th century. Today, the case in question happened in 1971. It's about a man whom the United States government in 1971 still insisted on referring to as Cassius Clay, but we know him as Muhammad Ali. And it is the story of what happened when his case against being drafted into the US Army during the Vietnam War reached the Supreme Court. What took place at the Supreme Court is truly remarkable. In this series, Politics on Trial, which I'm aware has been going on for quite a while now, goes all the way back to where we started with the case of Socrates, I've looked at all sorts of different kinds of trials and legal proceedings, political or in different ways, about power and power relations in very different kinds of societies, historical settings. But the kind of trial I feel we haven't had yet is what I would think of as a 12 Angry Men case. That is, a case in which someone holds out in a jury or the equivalent of a jury and turns the case around. Turns the other people on the jury around. A heroic holdout, or someone who at least stands his or her ground and somehow manages to persuade the others to examine their prejudices. I'm not saying that's what we're going to get today, but the case I'm talking about today is probably the closest. There have been other cases in this series that have little bits of the elements of the holdout, the one man among the 12 Angry Men, or rather the 11 Angry Men. The case of Mary Queen of Scots, where one brave, or perhaps paid off, aristocrat didn't vote for the execution of Mary Queen of Scots. It didn't make any difference to the verdict. She was still executed. Didn't make any difference to the man in question. He went on to have a successful career in late Elizabethan politics. Or the case of Louis XVI, much debated, not the question of his guilt or innocence, but when, in his case, it came to the vote in the convention on his punishment, would he be executed? It is always said that it was a vote decided by one. The majority was one. And some people have tried to identify the person in question. If that person had voted differently, maybe the case would have ended up with a different result. Historians have debunked that. It's essentially a myth. It probably is the case that the majority was more like 20 and there is no individual to be identified. There is the case of Oscar Wilde, the second of the three Oscar Wilde trials, the first criminal case against him, in which one juror held out. We don't know who, we don't know anything about what happened in that jury room, but in the end, it was a hung jury because the case required a unanimous verdict. There is a suspicion that that juror may have been making a political statement about Ireland and Irish nationalism. Who knows? It seems unlikely that the juror was making a political statement about the criminalisation of homosexuality. But A, we don't know who it was, so that story can't be told. We don't know what happened in the jury room, and it made no difference. After that hung jury, the prosecuting authorities decided to have another go at Wilde, and this time to make absolutely sure that he wouldn't get off. And he didn't. Today's case is closer to the 12 Angry Men scenario because it does involve one individual. In this case, we're not talking about a jury, we're talking about the United States Supreme Court. One individual effectively changing his mind and changing his vote. And as a result of changing his vote, a verdict that had been going one way ends up going unanimously the other way. And someone who would otherwise have had his conviction upheld, Muhammad Ali, found that his conviction was quashed. And as a result, he did not go to jail. So that is the closest we're going to get in this series to that scenario. But as I'm going to describe, it doesn't really fit the template. It is true that one individual, one justice, Justice Marshall Harlan, did, by all accounts, change his mind. And indeed, in some versions of this, and there isn't really documentary evidence, there is only anecdotal evidence of the people who were there, including some of the Supreme Court clerks. He changed his mind overnight from one evening to the following morning, and he changed his vote. And it is also true that as a result of that, the whole case was turned on its head. But it doesn't seem that he changed anyone else's mind. And the reason that the verdict came out differently was not because of his, Marshall Harlan's, powers of persuasion. It was more of a technicality. It is still, though, a completely fascinating case and a very rare instance of a Supreme Court judgment being turned on its head overnight. And it did also have pretty far-reaching consequences. So this story, the story of the man I'm going to call Muhammad Ali, but at the early part of this story, he was known universally as Cassius Clay. Cassius Clay and the question of his drafting into the United States Army. The story effectively begins in 1964. In that year, 3 or 4 or 5, actually, depending on how you want to pass it, things happened that set the terms of the argument that would culminate in the Supreme Court in 1971. There was a draft in place in the United States under what were called the Selected Services Laws that had been in place since 1948, which was originally a peacetime draft, but it had morphed into a draft that would be used first in Korea and then in Vietnam for war. Under the terms of that legislation, all American males at the age of 18 had to register with their local draft board. The young Cassius Clay, aged 18 in 1960, the year he won an Olympic gold medal in the light heavyweight division, registered with his draft board in Louisville in Kentucky, the place of his birth. In 1964, he took a test which was one of the requirements prior to anyone being drafted. It was effectively an aptitude test. Really, it was an IQ test. Because one of the criteria for the draft is that in order to be drafted, the person in question had to qualify in the 30th percentile or higher of this IQ test. And Ali took the test, age 22, in January 1964, and he came out with an IQ score of 78, and that placed him in the 16th percentile of the nation as judged by these criteria, which meant that he was exempt from the draft. With hindsight, it is astonishing that Ali scored 78. He was the most eloquent, verbally dexterous, straightforwardly intelligent sportsman of his era. That is how he is remembered. But it also appears that he was someone who had undiagnosed dyslexia, and he struggled with the written elements of the test. There was some suspicion that he might have faked the result, he might have deliberately flunked it. So he was retested later in the year, a few months later, in April 1964, by a panel of psychologists who concluded that it was a genuine failure in these terms. And there is also evidence that Ali himself was a little ashamed of his score. He said, when asked about it, "I said I was the greatest. I never said I was the smartest." It meant that he was exempt from the draft. Something else that happened in 1964 that exempted him from the draft is that he got married, age 22. And in 1964, married men between the ages of 19 and 25 were also exempt from the draft. So Ali was doubly exempt. In 1964, he also became the world heavyweight boxing champion in February in a fight which was considered to be a stunning upset. He defeated the reigning champion, Sonny Liston, and he became one of the most famous people in America and one of the most famous sportsmen in the world. So were his case ever to come to court, this would now be, almost by definition, a cause célèbre. And then the other thing that happened in 1964 is that is the year that he changed his name. Cassius Clay changed his name to Muhammad Ali. By this point, Clay had become very close to and involved in the Nation of Islam, the black nationalist and in many of its guises black separatist movement that was growing fast in the United States. It had a very mixed reputation, particularly among white Americans, many of whom were alarmed by it. And it made Clay a very divisive figure. When it was known that the world heavyweight boxing champion was also extremely close to Elijah Muhammad, the leader of the Nation of Islam, but also to Malcolm X, the most prominent member of the Nation of Islam, it meant that many boxing fans, white American boxing fans, were extremely uncomfortable with this man, Cassius Clay, as they called him, being the world heavyweight champion. In 1964, he changed his name. He actually did it twice. First, he changed it from Cassius Clay to Cassius X, following Malcolm X. But Malcolm X and Elijah Muhammad, by this point, had massively fallen out. They were basically in dispute, leading rival factions within the Nation of Islam. And Elijah Muhammad, when Clay changed his name to Cassius X, staked a claim to the world heavyweight boxing champion and his strand of the Nation of Islam by announcing in a radio broadcast that he was giving Cassius Clay a new name. And his name from now on, within the Nation of Islam, would be Muhammad Ali. So Muhammad Ali did not choose that name for himself. It was given to him by Elijah Muhammad. And in accepting the name, which he did, he was also effectively disowning Malcolm X, which he also did. He became completely distanced from Malcolm X from this point and affiliating himself with Elijah Muhammad and with that strain, that faction, which was the leading faction of the Nation of Islam. So by the end of 1964, Cassius Clay was Muhammad Ali. He was now explicitly affiliated with Elijah Muhammad. He was married, and even if he hadn't been married, he was exempt from the draft. In 1965, the Lyndon Johnson administration overturned the Kennedy administration's stipulation that married men would be exempted from the draft. The Vietnam War was ramping up, more men would be needed to be drafted, and the married exemption seemed to be too generous. Now, only married men with children would be exempt from the draft. In 1966, the rules were extended even further, and the aptitude requirement was dropped from exempting all of those in the 30th percentile and lower, and it was reduced to exempting those in the 15th percentile and lower. So from 1966, Ali was now draftable. He remained, at this period, the world heavyweight boxing champion, and he remained a deeply, deeply divisive figure. He was enormously popular in some sections of American society, particularly black sections of American society, and he was reviled, loathed by many white Americans. But he was also different from previous world heavyweight boxing champions, particularly previous black world heavyweight boxing champions. One of the problems that Ali posed for the people who wrote about boxing for a living, the white men who ran the sport, they ran the sport as journalists, as administrators, and many of them as businessmen, because black boxers in this period were also effectively run, almost owned, by syndicates of white American businessmen. One of the problems that Ali posed for all of these white men who in their different ways were the guardians of boxing, in their own minds anyway, is that he didn't fit into one of the two categories into which all black boxers were effectively placed. There were only two ways in the eyes of these white men that you could be a black boxer, particularly a black boxing champion. So among the world heavyweight champions, there were the people that these white men considered, you'll have to forgive this terminology, but it was the language of the time, the good blacks, the ones who played the part in the way they should. They were warriors in the ring. They were ferocious. They were killers. Boxing is not many steps away from the kinds of violence that results in death, and occasionally boxing itself results in death. This is warfare, and these men were utterly fearsome in the ring, but out of the ring, they were meek, they were mild, they were modest, they towed the line, they performed their public functions, and they didn't scare anyone. Indeed, The good black boxers were the ones who the white men who ran the sport were entirely comfortable seeing as world heavyweight champion. The definitive example of this kind of black world heavyweight champion was Joe Louis, who was champion before, during, and after the Second World War. During the Second World War, he volunteered for the army in 1942. He didn't fight. The United States Army used him for propaganda purposes. So Louis fought. He didn't fight, meaning he didn't fight in armed combat. He fought in the other sense. He performed a whole series of exhibition bouts around the world for United States troops. He was a credit, it was thought, to boxing, to his race. That's the language these white men would have used. And he was a good patriot. He was exactly the model for white America of what a black world heavyweight champion should be. His nickname, a racist nickname, was the Brown Bomber. Race was always central to boxing and the politics of boxing in this period. Another example of a good black world heavyweight champion was Floyd Patterson. And Floyd Patterson in 1965 fought Muhammad Ali for the world heavyweight title when Ali was the champion. And Patterson said of Ali and his membership of the Nation of Islam that he, Patterson, had a patriotic duty as an American, and also, he said, as a Catholic, as a good Christian, to defeat this man. This was a fight between Christianity, America, patriotism, and a man like Ali, who was a threat to all of those things. Floyd Patterson was exactly what the white men who ran boxing wanted in a champion. Unfortunately, in that case, Ali beat him. And then there was the other type, the men that were called by these boxing journalists who consider themselves the aristocrats of the sports writing profession, hard-bitten men, many of them themselves, hard-bitten white men who were totally comfortable writing about a black-dominated sport with racism bubbling just beneath the surface. The other kind of boxer they characterized was the thug. And the definitive thug was the man that Ali defeated for the title in 1964, Sonny Liston. Sonny Liston had grown up very poor and as a young man had been involved in robbery and violence, gang violence. He was arrested, charged, and jailed. And it was during his years in jail that he learned to box. So he was a boxer from the jail system. And the boxing journalists considered him an example of the kind of black man who, if he wasn't a boxer, would be a criminal. There were the good boxers and there were the thugs. And the problem that Ali posed is that he was clearly neither. He was not a thug. He was not a criminal. He had not learned boxing in jail. He was extremely articulate, notwithstanding the IQ test. Everyone recognized his articulacy, his lyricism, the poetry that he was already developing as part of his pre-fight hype. He was beautiful. Even these hard-bitten white men who wrote about boxing had to find the language to describe his incredible physical appeal. Unlike, actually, all of those boxers I described, Sonny Liston, Floyd Patterson, Joe Louis, Ali looked different. He didn't really look like a heavyweight boxer. He was not heavy set. He didn't lumber around the ring. He danced around the ring. He was light-skinned, something they all noticed. And his physique was much more like a Greek god than it was like a thug. He wasn't a thug, but he also wasn't good in their terms. He was angry, he was politicized, and, to add to the confusion, he taunted his opponents in this language that the white boxing writers of America liked to use. That is, when he fought Floyd Patterson, and Patterson said, "It's my patriotic duty to defeat this man," Ali taunted him as an Uncle Tom, as a white man's black man, as someone who was playing the white establishment line. And Ali was going to defeat him because he was a traitor to his race. When he fought Sonny Liston, he taunted him as a thug. He taunted him as dumb. He taunted him as a man who deserved to be beaten by the beautiful, elegant, articulate Cassius Clay, Muhammad Ali. So Ali didn't fit any of the templates, any of the models. He was clearly not just a new kind of boxer, not just a new kind of sportsman, but a new kind of celebrity in America. And his celebrity was enormous. And it was exhilarating for some, threatening for others, and many people did not know where to place him, how to pigeonhole him. And that was the man who in 1966 was drafted to fight in the Vietnam War. So he was no longer exempt, not on the grounds of being married, and in 66 he also got divorced, not on the grounds of his falling in the wrong percentile of IQ. And Ali resisted the draft on the grounds that he was a minister of the Nation of Islam, and he was, therefore, a conscientious objector. Initially, when Ali was told that he had been drafted, he said the single most celebrated thing that he said in the whole course of his 5-year struggle against the draft, the line that was endlessly quoted back at him and also on his behalf. Told he was being sent to fight in the Vietnam War, he said to the reporters who gathered in Louisville, Kentucky, "I ain't got no quarrel with them Viet Cong." Now, how you interpret that line actually became one of the central questions in the case, not literally the passing of those words, but the thought behind it. One possibility, and this may well have been true in 1966, that Ali was effectively saying, not only is this war nothing to do with me, but I don't actually know what this war is about. He wasn't particularly well informed at that point about the Vietnam War and more broadly about the political, the legal, the philosophical issues surrounding the draft. It was only when he got drafted that he got informed. So in 1966, there are some people who believe that what he was saying is, I don't know what this war is about. It's nothing to do with me. He was effectively pleading a kind of ignorance. In which case, he's going to be drafted, because the one thing nobody would be willing to argue in a court of law is that ignorance was a reason to be exempt from the draft. If Ali was going to be exempted from the draft, he would have to do it on the basis not what he didn't know, but what he did know, and what he believed, and the way in which those beliefs did not allow him to fight in this war. So he would have to learn what the fight was about. But then there were still two possibilities remaining. When he said he had no quarrel with the Viet Cong, was that specifically about the Viet Cong? And again, that is one way that that line could be read. Ali might be saying, there are certain kinds of wars in which I would accept I had a duty to fight, but not this one. This war in Vietnam against people who are also not white, and against people with whom Ali believed, not just he, but the United States should not have a quarrel. Was he saying he had no problem with the Viet Cong? Or was he saying there is no equivalent conflict in which he would feel that he personally had a reason to fight? And there is a big difference between those two positions. If Ali's position was he had a problem with the Vietnam War, that would be very hard to use as the basis for exemption from the draft. The only exemptions that seemed to be recognized by United States law were exemptions based on a general principle of opposition to all war, effectively a form of pacifism. The quintessential example of a group who were considered to be legitimate conscientious objectors under United States law were Quakers, and Quakers were pacifists. Quakers were opposed to war in all its forms. So one of the questions that would have to be answered if this case reached the courts, and the highest court in particular, what was the basis of Ali's refusal to be drafted? And the case did reach the courts because Ali did refuse to be drafted. So he made that statement when he was told that he was now up for the draft. He appealed to his local draft board in Louisville, Kentucky, that he wished to be granted conscientious objector status in 1966 because he was a minister of the Nation of Islam. The draft board requested guidance from the Justice Department, from the United States government, effectively from the Solicitor General, as to how they should proceed in this case. Ali's lawyers made the case, and the draft board wanted the case on the other side to be made. And the Justice Department said that it believed the draft board should reject Ali's conscientious objector claim. And so the board did reject his claim, and now Ali was going to be drafted. The next step that Ali and his lawyers took was to remove him from Kentucky and register him as resident in Houston, Texas, where it was believed he stood a better chance of having his claim upheld. But the draft board in Houston, Texas also rejected his claim, and in April 1967, Ali was summoned to his local recruiting station, where he was told that he was now being required to become a member of the American Armed Forces. And the tradition of that ceremony, and it is a kind of ceremony, is that when a draftee's name is read out, the draftee takes a step forward in order to signal that he is now signed up. So, in what was a relatively public ceremony, Ali did show up, his name was read out, and he very performatively refused to take the step forward. And it happened 3 times. It was almost a biblical event. 3 times he was called forward, and 3 times he refused to take the step, at which point he was clearly in breach of the Selected Services laws, and he was liable to criminal prosecution. And he was prosecuted. The first thing that happened is he was stripped of his boxing license the day that Ali refused the draft. The boxing authorities in America stripped him of his titles. He was no longer the world heavyweight champion, and refused him a license to box. So on that very day, Ali sacrificed his career and his income. He was, of course, by this point, an extremely wealthy man, not as wealthy as he would become. Too much of the money was going to the white businessmen who ran the syndicates, but still, Ali was foregoing effectively millions of dollars. And there were people who tried to persuade Ali that accepting the draft did not mean he would have to go and fight the Viet Cong. They held up Joe Louis as an example. Joe Louis, who had volunteered in 1942, had ended up just boxing for the United States Army in exhibition fights for troops around the world. And Ali could have done the same thing. But by 1967, Ali had educated himself about the war. He had started a tour of American college campuses where he spoke repeatedly and eloquently about his opposition to the war, and he had absolutely no intention of compromising on any of it. A couple of months later, in Houston, in front of an all-white jury, Ali was convicted, and he was sentenced to the maximum punishment under the terms of the draft laws, 5 years imprisonment. And at that point, his lawyers launched their appeal. And the appeal process lasted for 4 more years, during which time, until the very end, Ali was prevented from boxing. He had no license, so he had lost his income, in which he spent much of his time either performing, as he saw it, his ministry for the Nation of Islam, and, related to that, continuing public events, speaking events, debates about the war and about his opposition to it, becoming one of, if not the most prominent figures in the resistance movement against the Vietnam War. The case was appealed all the way up to the Supreme Court in 1969, but the court refused to hear it, and it was sent back down again. And it only came back to the Supreme Court in 1971, 4 years later, when the court did agree to hear it, under pressure from perhaps its most liberal justice, Justice Brennan. So in 71, the case would finally be heard at the Supreme Court. During the period that Ali had been arguing in public, very publicly, against the war and against his being drafted to fight in the war, he used a range of different arguments to bolster his case. One of them was that he was a conscientious objector, and under United States law, conscientious objectors should be protected from being drafted. Another of his arguments was that the system under which he had been judged was profoundly unfair because it was clearly, palpably racist. All of the legal bodies by whom he was judged were all white. The draft boards were all white. The jury in Houston was all white. The appeals were heard by all-white panels. No black Americans were allowed to express an opinion in a legal setting on this case. Ali was the victim of prejudice. He also argued, more pragmatically, that if the United States government wanted him to contribute to the Vietnam War, they would be much better off letting him box for a living, where he would make millions of dollars, and the taxes on those dollars would fund far more equipment, soldiers, military hardware than anything he could do, particularly if all they wanted him for was to put on exhibitions. Let him box, let him make money, tax him. He couldn't control what they did with his taxes. Don't draft him into the army. Now, not many of those arguments were going to cut any ice at the United States Supreme Court. The racism argument wasn't going to work. The tax me, don't draft me argument wasn't going to work. The only argument that was going to work was the conscientious objector argument. And by 1971, the United States Supreme Court had heard a series of test cases challenging the draft laws and expanding the range of individuals who could legitimately claim to be conscientious objectors. There were effectively 4 landmark cases, one in 55, one in 65, one in 1970, and one heard in 1971, very shortly before Ali's case was heard, which shaped and defined the terms of conscientious objection. The first case, in 1955, involved a man called Ciccarella, who was a Jehovah's Witness, and he claimed that being a Jehovah's Witness should exempt him from the draft. In 1955, we're talking about the pre-Vietnam, post-Korean War draft. Until that point, it had conventionally been understood that the only people who qualified as conscientious objectors were members of established and recognized religions. So Quakerism was fine, it had a long history. It was effectively a Protestant sect. But the Jehovah's Witnesses were too fringe for that under the conventional understanding. Ciccarella claimed that Jehovah's Witnesses should also count. The test then was, unlike Quakers, who were clearly pacifists, Jehovah's Witnesses were not pacifists. Jehovah's Witnesses did believe in the legitimacy of armed combat, particularly what they called the fight that would come at the end of times, Armageddon, which would be a war between good and evil, the godly and the ungodly. And it would be a war, not hypothetically, but really. Jehovah's Witnesses were not refusing to fight under all circumstances. They were just refusing to fight in the wars of the United States government. And the Supreme Court upheld Ciccarella's argument. His conviction for refusing the draft was overturned. But the court didn't do it on principle grounds. Essentially, it decided, maybe for pragmatic reasons, maybe because it wanted to expand the definition but was uncomfortable with the language that would have to be used that would embrace some of the claims of Jehovah's Witnesses. It did it on a technicality. It argued that the original appeal and the advice of the United States government had been inadequately handled and drafted. The grounds on which Ciccarella's original argument had been rejected was not explicit in the US government advice, and therefore on that basis, the conviction could not be upheld. So it both was and wasn't a kind of precedent. In 1964, a man called Seeger took his case to the court. It was heard eventually in 65. And his argument was, and we are now very much in the Vietnam draft era, that although he was not conventionally religious, he did not belong to any recognized religion. Nonetheless, he had deeply held and sincere ethical and philosophical objections against war. And as such, he conscientiously objected to being drafted. And again, the court upheld Seeger's case. His conviction was also quashed. Seeger was not drafted. In his arguments, in his lawyer's arguments, it was pointed out that though he was not a conventionally religious man, he drew on authorities, Plato, Aristotle, Spinoza were all cited, and he believed in principles which were effectively a proxy for a kind of belief in a supreme being. Though not conventionally religious, he was unconventionally ethical in a religious sense. And that was enough. He was sincere. One of the tests for conscientious objection was that the person claiming it had to show religious training. What that effectively meant was this couldn't be something that someone had come up with on a whim. There had to be historical evidence that this person had educated themselves in the beliefs that they were now claiming exempted them from fighting. And in Seeger's case, it could be shown he had spent many years studying the doctrines, Plato, Aristotle, Spinoza, on which he based his claim. He was sincere. He was the equivalent of religiously trained. And he was against all war, all warfare. And those became the three tests for conscientious objection. The belief had to be sincere. The person in question had to be able to demonstrate that this was not just a personal philosophy that they had arrived at, but something in which and for which they had devoted many hours, many years of study and training. And they had to be against not this war or that war, but all war. In 1970, another case involving a man called Welsh reached the Supreme Court, and Welsh was claiming merely that philosophical belief, so not philosophical belief that took the form of a kind of pseudo-religious belief, but mere philosophical principles, reasoned, argued, potentially atheistical principles, should be enough to qualify for conscientious objection. And again, the court sided with Welsh. So the definition had now been expanded to include non-religious philosophical objection, but it had to be sincere. There had to be history that the person in question had really invested in this belief system. And it had to be, as it was in the case of Welsh, opposition to all war. And then the final case, the one that was held just before Ali's case, involved a man called Gillette, who was pleading conscientious objection on the grounds that he was fundamentally and principally opposed to the Vietnam War, that the Vietnam War was morally indefensible, and his belief system could not and would not allow him to fight in that war. Now, by 1971, the view that the Vietnam War was morally and politically indefensible was pretty widely held in the United States, and it was pretty widely held on the United States Supreme Court, a number of whose justices were effectively, although they had to be very careful about this, known to be very doubtful about the war. Nonetheless, by a majority of 8-1, the court did not side with Gillette. The court decided that opposition to a particular war was not grounds for conscientious objection. The criterion that it had to be effectively a form of pacifism, opposition to all war, still held. So those were the circumstances under which Ali's case was heard. On that court, one of the justices recused himself, and it happened to be the only black United States Supreme Court Justice, Thurgood Marshall. He recused himself on the grounds that in 1966 he had been United States Solicitor General, and therefore he was involved in the original case against, as the court called him, Cassius Clay. Actually, he probably also recused himself because he really did not want to be involved in this case. As the only black justice on the court, there would have been a widespread expectation that he would side with Ali. But Thurgood Marshall had many years of history with the Nation of Islam, and it wasn't good. They had repeatedly criticized him as a sellout, as a white man's black man, as an integrationist when what they wanted was separation. And he had repeatedly condemned them as thugs. He called the Nation of Islam effectively a kind of prison creed because so many of its members learnt their religion, the Nation of Islam, while in jail. It would have been an incredibly uncomfortable case for Thurgood Marshall. He stepped aside. So there were now 8 justices. The case was heard, and it became clear very early on that it would turn on the question of whether Ali could claim to be opposed to all war. The Nation of Islam, which Ali claimed was a religion of peace, nonetheless was not opposed to all war. It believed in holy war, and its texts established that it believed in holy war, the war of the godly, the righteous, against the evildoers. And in that war, Ali had said repeatedly he would be willing to fight. He would fight to defend Allah. He would not fight to defend the United States. There could then be an argument about whether the Vietnam War was even a defense of the United States, but that wasn't the point of issue. Ali had made it crystal clear that he was not against all war. And for that reason, a majority, not the whole, but a majority of the justices decided that Ali's conviction would be upheld. And by a vote of 5-3, it was decided that Ali's conviction was sound, and therefore the 5-year sentence, the jail sentence, now would come into effect. It was decided by the Chief Justice, who had only been in place for a short time, a man called Warren Burger. This was no longer the Warren Court, the great liberal court of the 60s. This was now the court that was being reshaped by Richard Nixon. Burger was his appointment. So it was in a sort of hybrid state. It was no longer obviously a liberal court, but it still had many liberal justices on it, many of the leading lights of the Warren Court. But it was starting to move towards the later guys, a more conservative guys. In this hybrid state, Warren Burger tasked one of his fellow justices, Marshall Harlan, with writing the majority opinion, explaining the reasons why Ali was guilty, as charged, because he was not against all war. Harlan set about his task with the help of his young clerks, who presented him with the materials they thought he needed. And there is some dispute about whether this was deliberate or accidental, but they felt in order to write the majority opinion, Harlan should be better informed about the creeds of the Nation of Islam, what it is that men like Ali believed. And so they included in the documents for Harlan to read before he wrote his opinion, the autobiography of Malcolm X, which had been written with Alex Haley, and also the definitive statement of Elijah Muhammad, Message to the Black Man in America. Harlan went home, he read the materials that he'd been supplied with, and he changed his mind. He changed his mind because he applied the 3 tests that he understood the law required to be applied in a case like this. Was the person in question sincere? Was the belief system based on religious training or the equivalent? And was this effectively opposition to all war? And on the third point, after reading, he decided that this case was effectively the same as the Jehovah's Witnesses case that had been held in 1955, in the sense that, yes, it is true, men like Muhammad Ali believed in something they called holy war, a war that might come at some point and might indeed signal the end of a worldly era. But in this worldly era, no war would pass that test, and no war that was not instituted by and in the name of religious authorities on behalf of Allah counted as a war for which and in which Ali would fight. And that was enough. He was not objecting to the Vietnam War. He was effectively objecting to all the possible wars in which he might be drafted, because he was not going to be drafted by the United States government to fight a war for Allah. And once Harlan had reached that conclusion, the other 2 followed naturally. If it is the case that this does meet the criteria for objection to war, it was clearly sincere. Ali had given plentiful evidence over the previous years that he believed this stuff and he was committed to it. And it was the basis of serious training. He had educated himself. He was, in those terms, a minister of the Nation of Islam. He performed a whole range of functions for the Nation of Islam, and he had spent 4 years touring American college campuses debating this very point. So Harlan, the next day, told his fellow justices that he was reversing his vote, and a 5-3 judgment became a 4-4 judgment. A 4-4 judgment meant that Ali's conviction would still stand. It would have required a majority the other way to overturn it. But a 4-4 judgment meant other things too. It effectively meant the court had not reached a decision, so it looked to a number of the justices a little like an abdication of duty. It also meant, because it was a tie, the reason there are 9 on the court is to try and prevent a tie, but because one was recused, and therefore it was a tie, there was no opinion that could be written because the court had not reached an opinion. The court had no opinion on this case. The court was effectively mute. And again, that made a number of the justices, including a number of those who had cast their vote for the conviction to be upheld, uncomfortable. The idea that one of the most famous men in America, a man whose case against the Vietnam War and being drafted to fight in it had become a huge cause célèbre, could potentially go to jail on the basis of the Supreme Court effectively agreeing to uphold his conviction, but not giving its reasons, not explaining why, doing it silently, looked like a recipe for disaster. Political disaster, controversy, and damaging to the reputation of the court. And yet it wasn't clear what else they could do, because the 4 who hadn't changed their minds were absolutely adamant they were not willing to follow Harlan. They did not agree with him. They were not going to sit down and study and pass the works of Elijah Muhammad and the autobiography of Malcolm X. They were still convinced that Ali had made it clear he was not a pacifist. And if they were going to argue about the 1955 case, the argument would be, in 55, the court had not found, in fact, that being a Jehovah's Witness qualified the person in question for conscientious objection status. The court had simply ruled on a technicality. And so the court was stuck. It couldn't move forward in any direction. This was not 12 Angry Men. Harlan didn't come back, sit them all down, and persuade them all to change their minds. He was the only one who changed his mind, and he remained the only one who changed his mind. At the same time, it was thought to be intolerable that this incredibly high-profile case, that many of them were deeply regretful that the court had agreed to take, would result in a tie, with all of the consequences of that, and Ali in jail. What were they to do? Another justice, Potter Stewart, came up with the solution. He said, let's go back to the Cicarella case in 1955 and use that as a precedent, not the Jehovah's Witness precedent, but the technicality precedent. Let's look at the instructions that were issued by the Justice Department to the Draft Appeals Board at the origin of this case and see if they were adequate, and let us find that they were not adequate, because they did not specify which of the 3 grounds, sincerity, religious training, being against all war, Ali's appeal was being rejected on. And if it was not clear what the legal advice was from the Justice Department that was given to the appeals court, then the verdict of the appeals court, the draft appeal body, could not be upheld, because there was no basis on which to uphold it. And like in the 1955 case, the court could therefore set the conviction aside without, it hoped, setting a precedent, because the fear was, if Ali's grounds for refusing to be drafted were accepted, every member of the Nation of Islam of any standing or any duration could refuse the draft. And either in the back of their minds or in the front of their minds, those justices were aware that the United States draft was effectively a racist institution because it fell more heavily on black than white Americans. Black Americans were not simply more likely to find themselves fighting. They were more likely not to have the resources to find a way out of the draft, less likely to go to Canada, less likely to learn on college campuses how to avoid the draft. But if they were given this out, membership of the Nation of Islam, again, it was thought the political consequences might be toxic. Some of the justices, including the 3 who had originally voted to quash Ali's conviction, were clearly quite comfortable with that. This was the legacy of the liberal court. What's interesting about Harlan is that he was always a curious hybrid figure. He was both jurisprudentially conservative in the sense that he was very against an activist court. He did not like the court getting involved in questions that he felt should be resolved politically, legislatively. And the Ali case, clearly in his own mind to start with, was one such case. He did not want the court to get involved, hence his original vote. But he was also socially liberal, and he was against the Vietnam War. And something about that experience of reading those texts, we don't know what it was, persuaded him to set aside his small c conservatism and embrace the risks of establishing this precedent. His fellow justices would not let him establish the precedent, so a compromise was agreed. A unanimous verdict would be reached, and the justices decided 8-0 that Ali's conviction for evading the draft and his sentence, 5 years in jail, would not stand. And they would not stand because of the technical failings of the US Justice Department in its original deposition to the Louisville Draft Appeals Board. And that, they hoped, at least would set aside the possibility that this would open the floodgates to mass rejection by young black men of the United States draft. They couldn't just leave it at that. And in the opinion that was issued, it was also established, because it needed to be established, that the court believed that Ali was sincere in the statements that he had made about his objections to being drafted to fight in this or indeed any equivalent war. But it did not go down the path that Harlan had said he would have gone down if he could have persuaded one of the other justices to side with him, which was a detailed exposition of what it was that he found in the autobiography of Malcolm X and what it was he found in the works of Elijah Muhammad that persuaded him to change his mind. In a way, it is a shame that we didn't get that opinion, because it would have been extremely interesting to know how Harlan made the case. Instead, the court was able effectively to hide behind a technicality. Ali, by the time the judgment was reached in 1971, was boxing again. The boxing authorities had lost their legal battle to uphold their withdrawing of his license. The tide was clearly turning in Ali's favour. He was still a deeply controversial figure, but he had much more respect. And also the tide was turning against the Vietnam War. Ali looked less like an outlier, less like a representative of a fringe religious group whose primary calling card was black separatism and black nationalism, and more like the spokesman for a generation of young American men, many of them white, who did not want to fight in this damn war. In March 1971, a month before the Supreme Court reached its decision, Ali fought in what many people considered the greatest fight of his career. Some people consider the greatest boxing bout of all time, the so-called fight of the century. This is not the trial of the century, but that was, for some people, the fight of the century against Joe Frazier, a fight that Ali lost, his first defeat. After the Supreme Court issued its verdict, Ali went back into the ring and he fought a series of bouts. He regained the world title. He fought the famous Rumble in the Jungle. He fought the Thriller in Manila. He became one of the most famous men of the 20th century, one of the most beloved men of the 20th century, much more a cultural icon than a political figurehead, a man who seemed to transcend race for many people, including many Americans. He was still a devoted member of the Nation of Islam. He never took a step back from his religious beliefs or, in his own mind, from his profoundly held objections to war. But it is worth asking what might have happened if Justice Harlan had not taken those books home and instead had come back and written the opinion that his fellow justices expected him to write, simply establishing that Ali was not a pacifist. Would he actually have wound up in jail? I don't know, but he might well have done. But his conviction would have stood. And I think it's likely that the story of Muhammad Ali would have been very different. It would have been much harder for him to continue the resumption of his boxing career. The likelihood is he would have had his license to box withdrawn again inside or outside of jail. But also, I think, almost certainly, Ali's anger, his rage against the system, would have persisted. The judgment of the court, and Ali thanked Allah for it, he said it was clearly a blessing from God, took some of the heat out of Ali's politics and his political stance. This extraordinary figurehead of a kind of resistance movement in America. First, black nationalism, black separatism, but then more broadly, resistance to the Johnson administration, to the Vietnam War, to the direction of travel of the American state. That figure was defanged by the Supreme Court ruling. Ali went back to being a boxer, and it was as a boxer that he achieved his greatest fame and became this legend that he remains today. And in many ways, his fight against the draft, the period in his career between gaining the heavyweight championship as a young man and ultimately losing it because he went on boxing for too long, that period in between when he didn't box, when he toured college campuses and made the case against the war, that period has been not airbrushed out of his history, but it's a side note. It's not the main story. Had Ali's conviction been upheld, that was the trajectory that he was on. That is the path he must in some way have gone down. And the politics would have been the story, and the boxing, effectively, would have been the sideshow. Instead of which, by siding with Ali, I think the court inadvertently, I don't think it was its intention, depoliticized him. Depoliticized him to the extent that he became a kind of ecumenical figure in American life, in American politics. In 1984, Muhammad Ali endorsed Ronald Reagan for president as a godly man. Muhammad Ali, he became something above, beyond, not just politics, but all of the arguments that he had been associated with in the late 1960s. So the irony of this case, and I think the reason why it is nothing like a 12 Angry Men case, is that in one justice turning around the verdict of the United States Supreme Court so that a black American who was facing 5 years in jail ended up with his conviction quashed through a majority verdict, far from, in a way, vindicating that man's stance and cementing it, particularly the way the court reached its decision, the fact that the verdict was on a technicality, the fact that no one, apart from Harland, changed his mind. That verdict, far from being the culmination of the story, was the reason that this story is not nearly as well known today as it should be. We don't have many trials to go in this series of Politics on Trial. We've still got the trial of Saddam Hussein. We've still got the O.J. Simpson trial. But next time, the story moves outside the United States. I'm going to be talking about a case that happened in China and in some ways is the definitive late 20th century example of a show trial, and in some ways is the exact opposite of that. It's the case of the Gang of Four. And just a reminder that if you would like to hear part 2 of my conversation with Robert Saunders about the explosive impact of Irish Home Rule on British politics and how close the country came to civil war, that conversation is available now on PPF Plus, along with all of our bonus episodes, ad-free listening, automatic sign-up to our newsletter. All you have to do is sign up by clicking on the link in the show description or going to our website, ppfideas.com. Join us next time for the Gang of Four. This has been Past, Present, Future.